Originalism often comes into play in Supreme Court cases. I want to ask about originalism that's a little different, one that's centered on the original intent of charter law. The National Charter Schools Founders Library has a bunch of documents on these sort of founding founding legislators, perspectives on this. I want to read just a few. North Carolina House Speaker Howard Brubaker called charters a very novel issue to still have a public school called a charter school, and that his legislative opponents have a very difficult time arguing this is not a public school system because charters are going to get funding basically the same way the school system has. Florida Governor Jeb Bush, they're independent public schools that have discrete missions. Minnesota State Senator Rashad Young, chartering was to open up K-12 public education system to allow people other than school boards to provide public education. Parents and teachers, the key was to have outside choices so that the K-12 system would be more responsive. So, in some sense, an originalist lens might suggest these founders believed they were creating new types of public schools, and they included prohibitions for religiously affiliated charters. So I'm going to ask those arguing for this, is there evidence these founders could have intended otherwise, and does it matter?
Well, I don't think there is evidence that they were considering something else, but sometimes the legal issues take time to develop, and I don't think they could foresee changes in the law and changes in doctrine that we've seen over the past 7 to 8 years. And so there are certain implications of that. So even if that's what they intended, it doesn't necessarily mean that their intent gets to trump the Constitution and what's required by the Free Exercise Clause. Yeah, I think that's probably what they had in mind. But that was 1991, 1992. We get Trinity Lutheran versus Comer in 2017, and things start to dramatically change after that.
I actually wrote a paper for the National Alliance for Public Charter Schools in 2005 called Original Intent. I'll make sure that it's online so all of you can look at it. I asked this exact question. I looked at the preambles of all of the charter laws that existed at the time because there were lots of people saying things about charter laws that I thought were not true. I'll cut to the chase. There are 18 different purposes for charter schools underneath of their preambles. At that point, number one on the list was expanding options. Of these different purposes, one after another makes it very, very clear that the government was doing its best to create a sector of public education that was not run by the government. Public, but non-governmental. They created a sector of schools that were run not by the government, whose teachers were not employed by the government, whose teachers would not participate in a collective bargaining agreement with the government.